This is an appeal in the matter of Allianz Insurance PLC and others, and London International Exhibition Centre PLC and others.
This is key. My lady, my lords, I seize my primary task this morning to be so fantastically boring that most of the people who don't have anything to say today can vacate this room and attend remotely, and it might get cooler for everybody concerned. But having said that, I'll turn now to the substance of the case. I'm not going to waste any time because time is short. Therefore, I'm just going to say that this appeal is about the causal requirements of a hybrid disease clause. And that clause is to be found appended to a policy of physical damage and business interruption insurance. I'd like you, if you had it in paper form, but if you don't, I'll take you obviously to the electronic versions. But I'd quite like you to have the main policy wording available to you, and two extensions. One extension I shall dispose of pretty quickly. The main policy wording begins at CB, that's core bundle, divider 30, at page 497. And before going to that in any substance, perhaps you could look at the first of the attached schedules, which is at CB, divider 33 at 565.
It never ceases to amaze me, Mr. Keeley, how it is that the most important documents in a case find their way into two separate bundles, being right at the end of the first and the other one at the end of the second.
Right, anyway, I think we've got them now.
Yes, I'm sorry about that, my lady. I, of course, had the advantage over you because I just extracted them from the bundles and put them into a separate bundle.
Just about to do the same.
What you'll see from 565, which, because I was so lazy, I didn't actually extract, so I can't actually look at, but I assume that you can, is that towards the foot of that page, you'll see that the policy was entered into for a period of 1 year, way back on the 31st of May, 2019. So that was obviously decided before either of the FCA test case decisions, before Lords Legate and Hamblin had even gone to the Supreme Court. And for that matter, at a time when SARS-CoV-2 was merely a gleam in the eye of a progenitor virus-carrying bat. So this was the policy being entered before the pandemic, when nationwide lockdowns in response to disease were unprecedented in the modern history of at least this country. And the policy is to be construed, and this is an important aspect, from that perspective, not with the benefit of hindsight as to all or indeed any of the events of the pandemic. Now, one should never overstate the significance of the dangers of hindsight, but it's important in the context of this case. One should not assume that because, as we shall see and we accept, wide-ranging disease was reasonably contemplated when reference was made in the policy to notifiable diseases. The disease extension was designed, or in terms apt to cover, all the circumstances in which a notifiable disease can cause an interruption to the insured's business at the premises. Now I shall take you just for a moment to the award of Lord Mance in China Taiping. I need you to keep out the policies but nonetheless to have a look at this. It's in the authorities bundle at divider 64. This was another COVID case, much of which was concerned with the meaning of the words competent local authority. And if you look at paragraph 88 at 1569, and just to tell my lady and my lords that competent local authority was a relevant issue because the insurers in that case said that the closure of the premises, the lockdown, was not caused by any order of a competent local authority. And so the question that arose was whether central government fell within the description of competent local authority. And it was held by Lord Mance, or decided by Lord Mance, that it did not. And at the fifth line of paragraph 88, the policy cannot, however, be construed with the benefit of hindsight, see Arnold Britain. The express language of extensions 1 and 2 is heavily focused on localised incidents, likely to attract a response from the police or a local authority or body with local competence, even though there's nothing in it as such to exclude the responses of such an authority or body to a national or countrywide event or emergency. There is no reason, however, to assume that its language was designed or is in terms apt to cover all types or levels of executive or other intervention. The policy is to be construed against the background which existed when it was made and in the way in which it would then reasonably have been understood. And those are sentiments that we echo. And if you look at paragraph 76, which is at page 1560, just to remind you that we're talking about what happens when there is a central government response, but the phrase, if you look from 5 lines from the foot, the phrase is police or other competent local authority rather than central government. Lord Mance said, even if that were not so, such situations might in some circumstances be sufficiently serious to give rise to a central governmental rather than local response. It does not follow that policy cover extends to central governmental as well as local responses. So you don't tailor the interpretation of a policy to fit future facts, which the policy was not designed to cover or, in its terms, apt to cover. We can put that bundle of authorities away and go to the original insuring clause for the business interruption cover, and that's in the main wording at core bundle 30, page 516. This is standard wording. This is the damage wording before we get to the extensions. It is the business interruption. If damage by any of the covers insured occurs at the premises, to property used by the policyholder for the purpose of the business and causes interruption of or interference with the policyholder's business at the premises, the company will pay to the policyholder the amount of loss resulting from the interruption or interference caused by the damage in accordance with the provisions of the insurance. The covers that are referred to there can be found at page 508. And you will see at 508 that there are 10 covers. These are the perils, so you've got fire, earthquake, riot, flood, etc. And then at number 10, at the foot of the right-hand column, you have any other accident, excluding damage. Pausing there, it's obvious that the base cover for business interruption insurance, going back to page 516, is entirely focused on the premises and upon the causal impact on the premises or on the business at the premises of what occurs at the premises. So it postulates damage at the premises, affecting property at the premises, that is used for the purposes of the business at the premises, and causes interruption to or interference with the business at the premises. The entire causal chain is concerned from start to finish with what happens at the premises and not what happens elsewhere. It is fair to say that it is entirely premises specific. Now, that's not to say that what happens at the premises might not also have happened elsewhere. So you might get a flood. The flood might damage property at the premises and at the same time damage some property belonging to the business outside the premises. That is one flood, two, as it were, damages. But the clause is only concerned with and only covers the causal impact of the damage that occurs at the premises. It's unconcerned with that which occurs elsewhere, inasmuch as it is only the occurrence at the premises that's capable of being a proximate cause. That doesn't mean to say it cannot be a concurrent proximate cause. So if business interruption loss is caused by a flood, and that flood damages property at the premises and property belonging to the business outside the premises, and the business interruption loss is indivisible, as much caused by one as by the other, then the proximate cause of the damage of the property, of the business interruption, being the flood causing damage at the premises, operates in order to provide cover, so long as, of course, the causes are of approximately equal weight. So having looked at the original wording, we can now turn to the extension. And I'd like you to look at the schedule that was in force at the time of the alleged closure of the premises, or the closure of the premises, and that is in CB, that's core bundle, divider 32 at 547. This was the schedule in force at the time of the COVID lockdown in March. At 557, you find the relevant extension. And that says that the word damage, and the word damage, you will recall, even though you might not have it in front of you, is the damage in the standard business interruption section at 516. And that said, if damage by any of the covers insured occurs at the premises, to property used by the policyholder for the purpose of the business, etc. So the word damage is extended to include closure of the premises or part thereof on the order or advice of any local or governmental authority as a result of an outbreak or occurrence at the premises of, and it's A, any human contagious or infectious disease other than AIDS, an outbreak of which is required by law or stipulated by governmental authority to be notified, i.e. a notifiable disease. B, food or drink poisoning. C, vermin or pests. D, defective sanitation. So just like the base wording that we've looked at, this extension is exclusively focused on the condition of or in the premises and the causal impact on the premises of that which occurs at the premises. It insures against something, i.e. an occurrence of disease or other happening at the premises and not beyond the premises, causing the closure of the premises or part of the premises on the order or advice of a local or governmental authority, in consequence of which there is interruption or interference with the policyholder's business at the premises. This extension, like the base policy of which this is an extension, is entirely premises specific. That's the disease point, but also the companion limbs, and they are companion limbs, they're all together. The companion limbs of the extension, they're all, and each of them is concerned with premises-specific effects of premises-specific events. Food and drink poisoning, vermin or pests, defective sanitation. Now, in relation to those other companion limbs, it's in reality virtually inconceivable that any of those events or effects could occur in a manner that involved the closure of the premises without specific regard to the conditions at the premises, but in response to some overall phenomenon which merely happened, unknown to the authorities, to have manifested itself at the premises. So all the limbs of the extension, one can look at them each, but food or drink poisoning, vermin or pests, defective examination and disease, they describe situations in which the premises are closed specifically by virtue of an occurrence having taken place there, i.e., looking at the limbs, by virtue of there having been food poisoning there, or drink poisoning there, or vermin or pests there, or defective sanitation there. In other words, the occurrence having happened at the premises, and in consequence, or as a result of the occurrence having happened there, the premises are ordered or advised by governmental or local authority to be closed. That is our case. There is a direct and specific causal connection between what has happened at the premises and the consequential order or advice to close those premises, precisely because of what's happened at those premises. So pausing there and to summarise. The extension is a hybrid disease clause. It responds to interruption of or interference with the insured's business at the insured premises because of the closure of the premises or part of the premises on the order of advice of a governmental authority as a result of the outbreak or occurrence at the insured premises of those companion or of those limbs. Now, upon that introduction, the causal requirements of such a clause must, according to the authorities, long-standing, be determined as a matter of the proper interpretation of this policy, not any other policy, not an FCA type policy, not a policy which may disturb and trouble the other parties to the other cases before it. This policy is the only policy that you are to construe. And that determination of construction must necessarily, and indeed obviously, be made by reference to what would have been understood by a reasonable person in the position of the parties at the time when the contract was concluded, having all the relevant background knowledge reasonably available to them. So the only context with which this court is concerned is, we say, that the premises have to be closed by reason of disease being at the premises. Any normal person, including, therefore, insurers and the policyholder in my case, any normal person in May 2019, reading this clause in the context in which it appears as an extension in this policy, would understand the clause as meaning that it is the happening at the premises of disease, or of vermin, or of defective sanitation, which resulted in those premises' closure. The reason for the closure of the premises is what has happened at those premises. That's the required causal link between what's going on at the premises and the advice or order to close those premises down. That is without the benefit of any hindsight. We're going to go on to what if they had contemplated the possibility of a pandemic or epidemic disease. I'll go on to that in a moment. But any normal person reading this would say, it's what's happened at the premises that's resulted in the authorities closing down those premises. That is pretty obvious. And it's not a surprise, because if one can actually go back to China Taiping for a moment, which was in the authorities bundle at divider 64. Paragraph 86, one can start. That's page 1567. I'll come on to disease later, but just taking the other companion limbs. Little c at the bottom of the page, food or drink poisoning. Lord Mance is here looking at the legislation. The primary enforcement authority under the relevant legislation is a local authority. It is the council of each London borough, country or non-metropolitan county, the Common Council of the City of London, the treasurer of the Middle or Inner Temple, and the council of the Scilly Isles. Such an authority may, in case of drink poisoning caused by consumption of food or drink on the insured premises, could, if satisfied that the construction or state or condition of premises used by the business involved a risk of injury to health, serve an emergency prohibition notice imposing a prohibition on the use of the premises, etc. Going down to little d, vermin pests, under the relevant act, every local authority is under a duty to keep their district free from rats and mice. If you go a few lines down, a local authority may serve a notice requiring that reasonable steps be taken to destroy mice, rats, or to remedy the condition of the premises by cleansing and disinfecting, etc. You can see what else the local authority can do in relation to the premises because of that which occurs at the premises. Effective sanitation is no different. At the foot of the page, a local authority which considers that a drain is not sufficiently maintained and kept in good repair, etc., may take action to ensure the necessary works are carried out, including carrying out the necessary works itself. So any normal person, as I say, not just a reasonable person, any normal person reading this extension clause would immediately appreciate that what has provoked the attention of the authorities to close down the premises or part of the premises is precisely that which has happened at the premises.
Well, is that true of vermin? Suppose that in an area of Islington there's found to be an outbreak of widespread presence of rats.
Well, I would expect that only to happen in Islington, my lord.
Of course. But the London Borough of Islington says we're going to close all the restaurants on Upper Street, which is replete with restaurants, not by reference to knowing which ones have got rats or not, but we need to shut them all down and have them all disinfected. Would that not be something that a reasonable person might think might happen when this policy was taken out? I.e. a response area-wide rather than specifically to rats at one particular premises.
Such a person may reasonably contemplate that, but the policy doesn't reasonably contemplate that that is a covered risk. If somewhere, let's take one of these restaurants, has actually no rats or vermin, it's closed down. Well, the hard-edged rule means that that place has no cover. It's been closed down because of vermin.
Because there's no insured peril. But you were looking, I think, to persuade us that each of these companion risks, these companion insured perils, would be regarded by a reasonable person as perils in respect of which a response by the local government authority, or whoever it had to be, would only be specifically because of presence at those premises.
No, I have not said that.
Right, I misunderstood.
I've not said that, and your lordship's example doesn't quite tally with what I'm saying. Let's just say that the restaurants in Upper, whatever it is called, Street in Islington, has a rat infestation. This policy will provide an indemnity to those restaurants which are closed down because of the rats on their property. Doesn't mean to say that the local authority won't also be closing down the other restaurants because of rats or vermin in those properties. So the local authority may well say, I'm closing down all those properties with rats and vermin because they're all over the place. I'm closing down the whole street because that's the way it goes.
Yeah.
But you actually identified the peril. The peril is rats or vermin at the premises. So there has to be, or there have to be, rats or vermin at the premises in order for the peril actually to engage. As a result of the rats or vermin at those premises have to be closed down. I'm not saying that exclusively those premises have to be closed down. I'm not saying that there cannot be concurrent causation which applies. You may find that the council says, well, there are rats and vermin in 5 of those restaurants, but we're going to close down all 20 because we have to be, as it were, cautious.
We don't know which ones have got rats. There are an awful lot of rats in Upper Street.
Well, if you don't know which ones, then that's not good enough. If you do know, because what you've got to understand is that this policy covers the peril, which is that there are rats or vermin at the let's call it the restaurant, and that has to be the reason for the closure. If the government or the local authority knows or reasonably believes that there are rats there, for the purpose of which they need to close the restaurant down, that is a reason for the closure of those restaurants. It is actually rats being at those restaurants.
So suppose all the restaurants in Upper Street have rats, and suppose that they all have the same policy, this one. The council knows about, let's say, 10 of the 20 having rats, and it thinks that's good enough for me to close down the whole street. So the 10 who do have rats, but the council don't know that yet, aren't covered on your submission. Is that how it works?
That's not necessarily how it works. If the council knows that there are rats at all 10,
Well, it knows 10 out of the 20, let's say.
and can deduce from that there must be rats at the other 10, if that is the case, then the reason for the closure of the other 10 is because of the presence of rats in the other 10.
But it has positively to make that deduction, rather than say, I don't know and I don't care, I'm closing down the lot.
Well, you can put it that way. You can take that example and extrapolate a bit more, which is say I'm closing down all the restaurants in Islington. Now, if you take that example, because what you're wanting to do is prevent the spread of rats to all the restaurants in Islington, then that doesn't fall within this policy. There may be a rat in some other restaurant in Islington, but that is not good enough for the purposes of the policy. The premises are not being closed down because of rats at those premises. And if you then go back to Lord Justice Popplewell's example and what your Lordship has just said, if you are closing down the premises because of the rats or the rat infestation at those premises, then coverage is provided. If, however, what you're doing is taking a blanket approach on a generalized, indiscriminate basis to I'm closing all the restaurants because there is a rat infestation, then you wouldn't be saying that the closure of the restaurant is as a result of there being rats or rats having occurred at my premises.
Well, I understand that's your case. I was just stepping back a bit because I detected, I may be wrong, at the heart of your case, that at the premises cover does not contemplate an area-wide response, which is not specific to the particular premises. Have I misunderstood that?
No, you're almost there, but not quite.
Right.
The policy, right, okay, let's start again. It is not intrinsic as an intrinsic character of the policy. In fact, quite the contrary. That there is wide area governmental action. It is perfectly reasonably contemplated that there might be a rat infestation or a disease infestation of a wide-ranging nature. That is perfectly contemplated. Yes. But the policy, as opposed to the reasonable contemplation of the parties, which is, as it were, untrammeled by the policy does not itself demand that, that wide-ranging area response by a government is covered.
Well, I understand that, but I mean, at the heart of the distinction between at the premises clauses and radius clauses and the way they've been treated in the Supreme Court is this context of whether the parties would contemplate a wide area response rather than a response which was specific to the radius in the radius clauses or at the premises in our clauses. And you say not so. It's all focused on what happens at the premises, and therefore it contemplates a response to what happens at the premises.
Yes. The difference between you and me, my lord, and what your lordship has just expressed, and it's not a very big difference, but it's a tiny difference, but it might be relevant, is that the parties may reasonably contemplate a whole lot of things. But just because parties reasonably contemplate a whole lot of things doesn't mean to say that those things are covered. The policy contemplates, and that's the difference. In fact, the policy demands. Let's just deal with your radius provision for a second. And we'll go to the Supreme Court as necessary. The radius provision looks at something which is external to the premises. That's the first thing. Secondly, the radius provision intrinsically recognizes that what is external to the premises can, and for the purposes of the policy, will have had a business interruption impact on the premises. And so the radius provision has as an intrinsic quality to it that you will have necessarily wide-ranging governmental response. So,
Well, I'm taking you out of your course here.
no. If you're going to have, let's just take a small example. You've got a disease. Let's say it's a very infectious disease. Let's say you've got a radius of 1 mile or 25 miles. It really doesn't matter. Let's take 25 miles because it's more extreme and I like it more, therefore. Let's say you've got a disease which occurs 24 miles away. Now, as a result of the radius clause, you know that if that disease has an impact on the business of your premises, if it does, it necessarily will be a serious disease. That's the first thing. It'll be a wide-ranging disease, because otherwise it wouldn't have an impact on your premises. And also, it is intrinsic to the causation test, approximate cause, because if that disease is so serious as to have an impact on your premises as to provide cover, it will necessarily involve wide-ranging governmental authority response, because otherwise it won't have an impact on your premises. So there are two components, whether it is 1 mile or 25 miles. The first component is wide-ranging disease, which may reasonably be within the contemplation of the parties even to our contract. But the difference is the second component, which is that the government will respond to that wide-ranging disease with one wide-ranging action sufficient to impact your premises. So the radius clause intrinsically requires those two components, and indeed welcomes, because it requires those two components. An at the premises clause is not talking about external disease at all. It's talking about internal disease. Now, the parties may reasonably contemplate that a disease, an infectious disease, might be wide-ranging. That is entirely right. But the clause does not contemplate wide-ranging governmental reaction, because the clause contemplates action by the government because of the disease at the premises. Now, it's quite foreseeable, my lord, that the disease, if it is a rapidly and widespreading disease, may be present in locations other than the premises. But if one asks what sort of intervention a rapidly and widely spreading disease may elicit, there's a range of possibilities. It all depends on the particular facts. The authorities might close the premises, or, as in your example, the street, or, as in a wider example, the neighbourhood or the borough. Or they could do what happened in this case, which is basically to close the country down. Theoretically, all those responses are conceivable. It's at that moment that when you decide what the parties would have intended to amount to approximate cause, you are careful not to elide that which is conceivable, indeed, that which is perhaps even in the reasonable contemplation of the parties, and that which is covered. The fact that the authorities' response to disease could be extremely wide and indiscriminate in terms of response does not mean that you are entitled to manipulate the causal requirements in such a way as to encompass such a response. Put another way, the mere fact that it's known and appreciated that some notifiable diseases can spread widely does not tell you that blanket intervention, bearing no real relation to the conditions at the insured premises, must satisfy the causal requirements of the clause. That's the difference between the intrinsic nature of a radius versus an at the premises clause. And I'm going to develop this now. With respect to a radius risk, as I've already explained, generalized reaction to a disease as a whole, by the taking of measures that are not specific to the premises and which require the closure of the premises, whether disease has been found there or not, is intrinsically part of the radius cover. In other words, a radius clause is actually all about the risk of generalised government reaction to disease everywhere. That's because if you have a disease 24 miles away, and you know, because the policy tells you, that the business interruption losses that you suffer 24 miles away as a result of that disease are covered, that's what the policy tells you, you naturally and necessarily conclude that there will have been a generalised blanket response by the government, otherwise there wouldn't be a business interruption at your premises, and you necessarily conclude that it is intrinsic to that cover that generalised governmental response is indeed that to which the clause responds, and that is proximate cause within the reasonable intention of the parties. So the causal requirements of a radius clause must be construed so as to respond when the intervention of the authorities has nothing to do with the premises. Closes the premises down, but the intervention has nothing more to do with the premises than that the premises are closed. It's nothing to do with the condition at the premises. The condition at the premises for a radius clause doesn't come into it because you're closing the premises down because there's a disease 24 miles away or just short of 1 mile away. By contrast, generalised response to disease as a whole, by taking non-premises specific measures, is very much not intrinsically part of that premises cover. You don't need to contemplate cases anywhere outside the premises to make sense of the causal requirements of the at-premises cover. You don't need to contemplate cover for wide authority action for the cover to work. The case at the premises gives rise to the restrictions within the meaning of the clause without the necessary, or indeed, this is the clause, without the necessary accompaniment of any wide area response. So, what the ATP clause contemplates, is our submission, is a normal direct causal relationship whereby the occurrence of disease at the premises, being at the premises, and because it's at the premises, causes the premises or part of the premises to be closed down. Now, it's very important for you to understand that that does not mean that the disease or the cases of disease have to be confined to the premises to attract coverage. There might be cases of disease elsewhere, but cover is only given under the ATP clause if the premises are closed because of the presence of disease there. Now, is this unfair? Not at all. It's just the result of a typical hard-edged choice that the parties to the policy, insured and insurer, have made. Just pausing there, talk about hard-edged choices. This is a hard edge is actually a phrase which I've adopted from the Supreme Court. If someone 1 yard inside 25 miles with radius cover suffers business interruption losses as a result of the close down by the government in March 2020, that person can recover. If someone with a radius clause of 25 miles cannot prove under a radius clause that there were cases or a case of disease within the radius, that person does not recover. It may be that both of those persons, of course, have suffered business interruption losses as a result of the closing down of all the premises. Of course that's the case. Why? That's the case. It's a hard-edged choice of 25 miles, or it could be 1 mile. It could be anything. I have a friend with a hotel in Dorset. He's desperate He has a wonderful radius clause. He's desperate. He's been desperate for months, years, to find someone who had COVID within a mile of his hotel so he could claim for the closure of his hotel. I've told him to go out, find someone. Surely there's someone out there. His hotel is 4 miles from where I am, and it's really quite remote. I said, surely you must be able to find someone who fell ill or felt ill before March 2020, and he can attribute that perhaps to COVID, and then maybe you can claim against your insurance. I'd look at his policy. I told him that's what you've got to do. Poor chap, he can't. He hasn't looked hard enough, in my view. But that's a hard-edged rule. This is, you might say, oh, it's terribly unfair. Well, I'll come back to that in a minute. It's not unfair at all. If you take out cover with a 1 mile radius, you may be better, if you've got a radial cover, you might be worse off than if you had 25-mile radius. That's what you've bought. So coming back to your example about Upper Street, I'm not familiar with Upper Street. But if you come back to your example, what have you bought and what have insurers agreed to provide you with and why? Let's talk about the why for a moment. Why have insurers provided you with that premises cover rather than a radius clause? Or rather than some some disease clause, as there was in Hiscox, without any radius, if your business is interrupted or interfered with as a result of disease, will indemnify you. Why have insurers not done that? Well, Lord Mance in China Taiping gives one of the answers. When insurers give out these policies, the last thing they want, and the thing that they often think about, is accumulation of risk. You can provide, at the premises clause, to a whole lot of properties, businesses. Now, you may not want to focus, or you may not want to concentrate them all in London, because if there's a problem in London, and there's closure of each of those premises because of what's in them, then you may say, oh, I've got too much of a concentration of London, or Birmingham. If you say, I'll cover disease anywhere in the country, that is the biggest accumulation risk you can possibly expect if you're looking at the territorial limits. So, why is there a radius? A radius is another reason why you're looking at accumulation of cover. There is a limitation to the cover you're providing. Now, with a radius clause, you are also actually saying, I will cover you against wide-ranging responses, but you're looking at a radius. If you're looking at the premises clause, what you are doing as an insurer, just as if you were saying, I'll give you cover for local government authority response, not for central government, local government, is you are reducing your accumulation risk. So if you go one moment to China Taiping, where this is touched on by Lord Mance, it's back in Divider 64. You go back to 1574. Just to explain to you the context, paragraph 104, the first sentence. Contrary to policyholders' case, limitation of cover, a limitation of cover, by reference to the actions, instructions or advice of a local as opposed to central governmental authority, also appears to me both to have an understandable aim and to be readily conceivable. And then he goes through the legislation. But if you turn over the page, 105, as to the sense of such a limitation viewed generally, there is likely to be a great difference between circumstances and emergencies which call for no more than a local response and countrywide circumstances and a countrywide emergency that calls for central governmental intervention. The greatly increased potential for accumulation of exposure in the latter case is obvious and is one which I consider that reasonable parties and policyholders must be taken to understand. So, why in our case does an insurer say, I'm not giving you radius cover. The cover I'm not giving you one radius cover, two radius cover with 25 miles or radius cover with 1 mile, or radius, 1 mile by the way, is you're looking at Mansion House Tube Station, the British Museum, the Tate Modern and Trafalgar Square. You're talking about 3.14 square miles. So why does the insurer not provide a 1 mile radius cover to someone in London? Because something in the Savoy Hotel may cause the government to say, I'm closing down this bit of London, the City of London extending to the Temple and the Royal Courts of Justice, I'm closing it down. It's all within 1 mile, rather like Upper Street. Why does an insurer not want to provide that? Because he probably, or it probably, or might, insure 50 businesses within that 1 mile radius. And if there is just one local governmental, Westminster or whoever it is, response, closing down, and the city, closing down that area, that insurer is in a bad way. So, that insurer may provide 25 miles. He may not worry about accumulation of risk because maybe he insures only a few people. I don't know. Why does an insurer say ATP cover, not radius cover? Because that insurer wants to confine the cover, to limit the cover he is providing to those businesses who suffer a business interruption loss because of what is happening at those premises. He's not prepared to insure against business interruption losses caused by things external to the premises, unless there is something within the premises which has proximately caused, because of it happened there, that business interruption. So, talk about vermin and pests, come back to Upper Street. What the insurer is saying, look, I'll give you cover if you've got vermin and pests, and you're closed down as a result of vermin and pests. And Lord Justice Popplewell comes along, he pops up and he says, well, hang on a second. The local authorities closed down the whole of Upper Street because there is a pestilence of rats, a plague of rats. And the insurer says, I really don't care. That's not the cover I provided you with. I'm not providing you with cover against a generalised response which has no specific reference to your premises. It's no good saying, I'm a restaurant. And the answer is going to be, I really don't care. You are a restaurant. Of course you're a restaurant. But hang on a second. If you're closed down because of rats at your restaurant, fine. That's the deal. You may have rats, but if that's not the reason why you're closed down because of generalised response, that is not the deal I made with you. I don't want that type of deal. I insured all the other restaurants in Upper Street. That is not what I'm doing. And then the insured comes along and says, well, that's terribly unfair. In fact, there was a case of rats at my restaurant. No one knew about it at the time. But actually, I can prove, because I have scientific evidence which has come round to my restaurant and has located rat droppings dating from March 2020. I can prove there was a rat at my restaurant. Therefore, surely, Mr. Insurer, since the government was reacting to disease, let's call it rats in the abstract, it was reacting to instances of rats everywhere, and there was one rat in my restaurant. In other words, exactly what I've told my friend down in Dorset to find. Now, your response would intuitively have been, well, that's not enough. Because that's not the level of focus on the premises that is contemplated by the clause. The fact that you can find that there was a rat in your restaurant does in no way mean that your premises were closed because there were rats in your restaurant, or there was a rat in your restaurant. What the authority was not responding to was not responding to the fact of the rat having been in your restaurant when it ordered your restaurant to close.
It was responding to the risk that there might be a rat in your restaurant.
Exactly. And that's not good enough, because that's not an occurrence. So,
Even if the risk manifested itself?
Well, let's say that the risk had manifested itself, and the insured then says, well, I'm reacting to the case. The insured says, well, the government was reacting to the case at the restaurant because it was reacting to all cases of rats everywhere, and the case at the restaurant was one of those cases. Exactly your example, my lady. Your answer would be, well, actually, that's not enough, because it's not the fact of the rat being at your restaurant to which the authority was responding when it ordered the closure of your restaurant. The rat could equally have been anywhere. In other words, the government, when responding, wasn't saying there's a rat at your restaurant, close down. The government is saying there are rats everywhere. So rats in the abstract everywhere.
Including at your restaurant?
No, because the government doesn't know that there are any rats at the restaurant. It knows that there are rats everywhere, and it really doesn't care whether, and this is the point.
If it knows that there are rats everywhere, it knows that there are rats at your restaurant.
It doesn't care that there are rats in your restaurant when it closes your restaurant down. And my lady, to say that it knows that there are rats everywhere doesn't actually mean that it knows that there are rats at your restaurant. It's rather like COVID. The fact that COVID may have been everywhere, unfortunately, doesn't mean that there was COVID within a mile of my friend's hotel. There was no COVID within a mile of my friend's hotel. It's no good saying, as the insurer might say, well, there was COVID everywhere. There was COVID everywhere, but there were no cases within a mile of my friend's hotel. There were no cases in the Scilly Isles. There were no cases of COVID, even though it was everywhere. Everywhere is equivalent to everywhere and nowhere, because there was COVID, but when the government was responding, closing down my friend's hotel, the government wasn't saying there's COVID at your hotel. The government was providing a generalised response to COVID everywhere, all the information it had about COVID. So, you're right and you're wrong, my lady, if I can be so bold and insolent as to say that in that way. You've got to go back again to May 2019 and ask what a reasonable person, you'll say, well, you're a reasonable person, you're giving me the answer, so buzz off, Keeley, you're talking rubbish. But you've got to ask what objectively...
Far more eloquently than I could.
But the meaning will be the same, my lady. But so you look at this, you've got to go back to the clause. And you can't just say in a generalised way, well, there are rats everywhere, and therefore that's the reason why your restaurant was closed down, because there were rats also at your premises as well as everywhere. What a reasonable person would say, looking at the clause, is that that which is at the restaurant must have produced the response by the government to have closed that restaurant down. That's the normal thing that anyone would have said. I'm talking about normal people.
It actually boils down to a very simple point, Mr. Keeley. You say, in order to show that the clause is insects, it bites, it has to be shown that the closure order was a direct result of somebody knowing that there was a rat at the restaurant.
No, well, again, yes and no. It must be a direct result of there having been a rat at the restaurant.
Well, you can't know something if it doesn't occur, so...
No, it has to have occurred.
Yes.
You don't necessarily know about it, of course, because it may have occurred without your knowledge. But what I'm saying is slightly different, but almost the same as what your Lordship has said. There must have occurred a rat at your restaurant, and it's that occurrence of the rat at your restaurant that must have engaged the response of the closure authority.
How can that happen if the
You
local
don't know
authority
about
doesn't know about it?
Well, you have to, knowledge is a concept which you have to consider. It doesn't have to have been reported necessarily to you so that you know about it.
So what is the state of knowledge then?
You have to believe on
Awareness.
reasonable grounds. It's the Royal Insurance, it's the Royal Hotels case of Mr. Justice Mance. As he
All right, so if the authority in question has reasonable grounds to believe that there's a rat on your premises, and there is in fact a rat on your premises, and in that reasonable belief it issues a closure order in relation to the premises, then the policy responds.
Yes, because that is the reason why your premises are closed.
Right.
The reason your premises are closed is because of the existence of a rat at your premises. It is the being, as it were, the rat being on your premises has caused the closure of your premises.
And you distinguish that from the case where there is a rat at your premises. The government knows that there are more rats around than it positively knows about, and closes your premises along with a whole load of others.
That's absolutely right.
That's the distinction.
That is the distinction, because that generalised response, which comes in with a radius clause, it is simply not that which the policy, I'm not talking about the party's reasonable contemplation, but the policy contemplates as covered. There is a distinction. I can, for example, say I'm only covering rats which at your restaurant, which exclusively have caused the government to close your restaurant. Exclusively. In other words, there must be no concurrent rats outside.
Directly caused some kind of language.
Yeah, but exclusively. Now, obviously, because you're telling me, and I agree, you can reasonably contemplate that if there are rats at your restaurant, they're going to be next door. If there's an infection of rats or a plague of rats, they're going to be everywhere. But so you reasonably contemplate that, and so the insured can't come along and say, well, we all reasonably contemplated that as a possibility. The answer is, yes, we all did. And look at the limitation that I've put in your policy.
These policies carefully didn't use that kind of wording, which is solely and directly that kind of limiting factor. And that was one of the points that the Supreme Court made in the FCA case.
That is also true. Didn't say indirectly or anything like that. Certainly didn't also say only. So we're not going for what it's worth. We're not going for only. We accept concurrent causation perfectly happily because it seems to us to be the fair and the right result on the wording of this policy. There's nothing which says exclusively it must be at your whatever it is premises, in this case the centre. It doesn't say that. It can be elsewhere, but your centre has to be closed down because of that which is at your centre. Not because of that which is everywhere, irrespective,
including at your centre.
But irrespective of whether it's at your centre. It may be at your centre. The government didn't say, well, there's COVID there. It may or may not be. What the government was saying is, I'm closing the country down. It didn't say to itself, I'm closing the country down because it could have done this. It could have done this. It could have said, I'm closing the country down. The experience we've just had at Cheltenham in March 2020. There they all to Cheltenham and all got. It could have closed down Cheltenham as well. By the way, don't think this is at all heterodox. If you could go, my lady, my lords, to it's in supplemental bundle. You can put that away. sorry, I was trying to find a reference. I can hardly read at the best of times. I remember there were arguments below that this provides illusory cover. That certainly was in relation to the Ageas clause in FCA, the conclusion of Lord Briggs, that if insurers' causation arguments, which were but for in that case, they were not this case. The arguments there were but for. And Lord Briggs, and indeed echoed, but less stridently as it were, by Lords Hamlin and Leggett, if the insurers were right and the but-for test applied, then in the instance of a pandemic, which the Ageas clause was designed, because it was intrinsic to a Ageas clause to cover wide-ranging governmental response to a pandemic, the cover would be illusory. Well, the cover here is not illusory at all. All you have to do is go to the companion limbs, and you'll see, certainly in relation to vermin and pests and things, it's not illusory. But the idea that central government or local government does not respond to premises-specific disease or premises-specific events is completely and categorically wrong. We know that that's exactly what happened in relation to SARS, not SARS-CoV-2, but in relation to SARS. We know that's exactly what happened when part of the Metropole Hotel in Kowloon was closed down, but and they also ordered the isolation of Kowloon apartment block. But looking at what this government, not this, yes, well, it was this government, albeit a different prime minister, what this government did, one can go to supplementary bundle 19, and one can go to page 97. You will see at page 95, that's the Prime Minister's statement of the 3rd of July. And at page 97, he says in the middle of the page, that's the Prime Minister, to achieve this, we need to move away from blanket national measures to targeted local measures. So instead of locking down the whole country, we'll lock down specific premises or local areas where the virus is spreading. Instead of closing down non-essential retail and hospitality nationwide, we'll only shut establishments locally as required. Instead of shutting all schools for most pupils, from September we'll only shut those schools where it's absolutely necessary to control an outbreak. And the example of Weston-super-Mare Foot, we identified an outbreak in a hospital, closed it to visitors and new admissions, etc. And there are plenty. Then if you go down to the next page, there's an outbreak at a meat packing plant in Peace. And then you look at Leicester, which was community-wide, mobile testing units. And so there were specific measures taken in relation to Leicester. But then if you go on to if you go back to the Health Secretary's statement, page 90 of the same bundle, you'll see that the Secretary of State for Health, page 90, he repeats at the foot of the page, we shut Western Hospital, we closed 2 GP surgeries, meat processing factory in Canada. Welsh Governance Code Factory in Anglesey in Wrexham. And the next page, page 91. Individual cases are identified and managed by NHS test and trace. When many cases are found in one setting, be it a care home, for instance, a factory hospital, that's classified as a cluster, and be dealt with largely with public health, who has statutory powers to close organisations. And he goes on about a new outbreak and the possibility of a range of local and national actions may be needed. And there are plenty of examples. Now, you may say, yes, Mr. Keeley, but that doesn't cover what happened in March 2020. And I will say, snap, it doesn't, because that's not what occurred. Now, so, just to repeat, the centre, that's the Excel centre, was undoubtedly closed as a result of disease, COVID-19. But that does not follow, as I think I've said before, that for the purposes of the policy, the case of disease that we accept can be proved to have occurred at the centre was a proximate cause, concurrent or other, of the closure of the centre. The centre, of course, was not closed because of any connection, let alone any causal connection, between the centre and any case or cases of disease. The centre was not closed because it identified the place where COVID had occurred. It was not closed by reference to anything specific, or indeed relating to itself at all. By that I mean what was in the centre, or the condition, or the situation of the centre. There was no causal link between the centre as a premises, where any cases of COVID had occurred, and its closure. In other words, the reason for the closure was not disease having occurred there, or the happening of disease there. So it's really, in a nutshell, our case, and the question that you have to ask and answer. The question, more aptly, is on the proper construction, it's very boring, but on the proper construction of the causal requirements of the policy. Did the accepted case or cases of COVID at the centre proximately cause the closure of the centre in circumstances where that closure was implemented by national government action taken in response to the general prevalence of COVID-19 in the United Kingdom as a whole, and without paying specific or indeed any regard to the possibility that any case or cases of COVID might or might not have occurred at the centre? The answer of the policyholders and the judge is yes, and we say that that is not enough. That is not to say, this is very important, that the case or the cases of COVID that can be proved to have occurred at the centre made a causal contribution. It might have been terribly small, but it made a causal contribution to the closure by the government. That is my latest point. But in the particular, and it may be that it made a contributing cause or contribution. In other words, that may be enough to justify describing that case as a contributing cause to the closure or of the closure. But in the context and on the particular language and the scope of this policy, and that is the only context that is relevant for you to consider, that is not enough to amount to approximate cause of the closure. So I emphasise the particular context, the particular language, and particular scope of this policy. I do not address any other policy, and I certainly do not address the policies considered in the FCA test case, none of which was this policy. So it is not enough to satisfy the proximate cause test. We accept the proximate cause test. It's not enough to satisfy the proximate cause test when premises are closed by reason of disease in general, when it is the general presence of disease everywhere, which merely happen to have included one or more cases which are capable now of being proved to have occurred at the premises, where the occurrence at the premises was entirely irrelevant to the decision to require the closure of those premises. That is not sufficient to amount to approximate cause. This is not the but-for test. It is a proximate cause test. Now, is that a convenient moment, my lady, my lords, for a 5-minute break?
Yes, very well. We'll take 5 minutes.
I would like to call the board back and recording is still going on just because of technical difficulties with starting and pausing it. So if you do any conversations,
Good, thanks.
How are we doing?
You're doing really well. Midpoint.
How are you doing?
Midpoint occurred to me yesterday. Actually, disease is everywhere.
All rise if able.
My lord, what I've tried to do is to address the issues in the right order, in the sense that I've gone to the clauses and invited you to consider the meaning of the clauses without being, as it were, disturbed too much by FCA. And that is the right order in our respectful submission. And you've got to look at the clauses. And if you then want to look at authorities and see whether the authorities have any bearing upon the meaning or your thoughts, then you go to the authorities and see what influence they bring to bear. And what you don't do is pay lip service to the principles of construction, but actually all at the same time say, well, I know the FCA is there, I can't ignore the fact that FCA is there, and what I really want to know is why FCA doesn't demand the answer that the policyholders contend for. One of our major criticisms that we make of Mr. Justice Jacobs' judgment, and that followed essentially the submissions of the insureds, is that the judge approached the construction of the causal requirements not from an initial basis of what the words mean in the context in which they appear, etc., but instead by asking what he describes as the critical question of whether the causation reasoning in the Supreme Court in FCA in relation to the various radius clauses can properly be applied to an at premises case. Now, I'm not saying that's the wrong thing to do at some stage, but I fear that if that's the way in which you approach it, then it's likely to cause a wrong turn. The judge said at paragraph 174 of his judgment, which you will find at core bundle 28, and my lady, I'm really sorry that the judgment is not at divider 1 of the core bundle, but is in divider 28. I have to say that fortunately I played no part in its location.
Well, that at least is not your fault, Mr. Keeley.
I'm not blaming
It's
you,
the way
Mr.
these
Keeley.
core bundles are organised.
It's about time we issued a practice direction that changed all this. But that's for another day.
For all I know, it was done in alphabetical order. A is appeal, B, and anyway, J is tab 28 because it comes after something which begins with G or something. I know not. But if one goes to the judgment, and you start at paragraph 171 at page 416, the critical question is whether the causation reasoning of the Supreme Court in relation to the various radius clauses considered in the test case can properly be applied to at-premises clauses. Ultimately, this is a question of construction, and then the learned judge sets out the basic principles. But at 174, he essentially reverses slightly and says, although these are the relevant principles of construction, I agree with the policyholder's submission that I'm not dealing with the question of construction starting with a blank slate by applying the iterative process of construction, i.e. considering the language of the relevant policies, etc., as though the Supreme Court decision did not exist. The Supreme Court has considered the question of causation in the context of the very same COVID-19 pandemic with which I'm concerned. It's done so against a factual matrix which is not materially different in relevant respects. Well, just pause there. I seriously disagree. To the matrix against which the present contracts of insurance were concluded. The test case was decided in light of facts which were agreed, and that is true, and these have been incorporated in the agreed facts in the present case. Perhaps I was overcritical there, but the factual matrix, if the learned judge is talking about the facts outside the policy, then I withdraw my criticism. Then he says, at 175, there are also very obvious similarities between the clauses considered by the Supreme Court. Now, just pausing there, my lady, my lords, one is taught that you never construe one policy in the context in which it is concluded by reference to what might be described as similar policies, even similar clauses in different contexts. That is entirely heterodox. So the very obvious similarities is really a diversion that the learned judge shouldn't have engaged in. Each of them provides coverage in respect of notifiable infectious diseases. Each of them refers to the premises of the policyholders. It's true that the test case contains the reference in the context of rates. However, the two of the clauses in the FCA test case expressly applied to occurrences which were both at the premises and within the relevant radius. And there was no suggestion by the Supreme Court that a different causation test applied to these two aspects of the clause. Well, just pausing there, I'm not concerned with a clause in my extension which covers them both. I'm not concerned with that clause, and the Supreme Court did not consider at all ever the causation requirements of an at the premises section of the clause. The Supreme Court did look at the premises. I'm going to show that to you later. But the Supreme Court did not decide the point for at the premises. And then he says, a clause which simply covers occurrences within the radius will encompass, even if it doesn't say so expressly, occurrences at the premises. In other words, the radius will start at the centre of the premises rather than at their perimeter. Well, I don't agree with that either. It depends. If you say, for example, we know that the centre is very large. So if you said within a radius of 250 metres of the centre, you wouldn't get outside the centre because it's so large, that would be inside the centre. So that's not a terribly good example. That's the first thing. Secondly, the Supreme Court was not concerned with, as I've said, an at the premises clause and what that entails in contradistinction to an at a radial clause.
So you say radius clauses exclude an occurrence at the premises?
No, we don't say that.
So
we
where
don't
does,
say
where
that.
does the radius? Where is the radius measured from?
It all depends on the. It all depends on the circumstances. If you say there's disease within 250 yards of the whatever it is, the premises, it could include the premises within the radius. But what you are looking at with such a clause is what is intrinsic to the radius, because the radius includes the premises. In other words, the premises is entirely subordinate in that case, in that context.
I understand you say that radius clauses are not limited to the premises, and that's what differs. I just wanted to be clear as to whether you were taking issue with what the judge says at the bottom of 175.
Well, yes, I do.
They do cover occurrences at the premises as well.
Well, the radius will start at the centre, and I'm saying that is wrong. It depends on the clause. It depends on the circumstances.
It's a radius, of course. It starts in the centre.
It must start somewhere if it's a radius.
Well, it may.
Radius is something that goes round the middle.
Well, well, it depends, because the premises is not necessarily the centre of the premise. The premises.
You mentioned a minute ago, if you say 250 yards from the premises, well, that's 250 yards from any point on the perimeter of the premises. But if you have a radius clause, that must assume a circle with a centre, surely.
Yes.
Well, if I said with a radius of 10 yards of this chord, let's make it easy. If I said within a radius of 1 yard for this chord, and I presented myself right there, would you say that the radius extends, say, to Miss Ananda and no further? I would respectfully suggest you wouldn't say that. You'd say, well, the 1 yard starts at the door, and so you've got a yard around the court, because that's within a radius of the perimeter of the court. And the radius is not the circle just there. In other words, that which is out with Miss Ananda is in the court, and that which is out with the court is probably within the radius. I don't think there's much controversy about that. Well, if there is, then there shouldn't be. So, now, I'm obviously going to be beaten about the head and the body throughout the entirety of this case, as are all my confrères on, as it were, insurer's side, about the FCA case. The one thing a court of appeal has to do is not be, as Philip Le Téméraire was, rash, but you've got to be robust. Just because the FCA Supreme Court said something doesn't mean to say that it is slavishly applicable to something else. And our respectful submission is that it was wrong of the judge really to adopt the subordination rule, as it were, which is to say, well, we have the FCA Supreme Court case. Why should the losses caused by disease in our case not be covered for the same reasons as were determined by the Supreme Court to be applicable to the terms with which the Supreme Court was taken? We also say that in that way, the judge wrongly presumed that the Supreme Court's decision would supply the answer to the question when that was the fundamental question on which he needed to keep an open mind. In other words, he didn't have an open mind because he was tainted by the Supreme Court. It's important to note that neither the Divisional Court nor the Supreme Court was asked to resolve or did resolve any issue in relation to at premises clauses. The Supreme Court was not asked to and did not say anything about causation in at premises clauses or cover. Paragraph 175 at 417 is, in our respectful submission, an illustration of the extent to which the judge wrongly presupposed that FCA supplied the answer to the causation issue before him, instead of considering ATP clauses on their own terms. Secondly, the Supreme Court did not purport to create any default or general presumption that its causation analysis would or should apply to all COVID-19 business interruption claims under other types of clause, particularly ATP clauses, unless there was good reason not to do so. Thirdly, on the contrary, if one goes to the Supreme Court decision and one turns to paragraph 190, the Supreme Court decision is to be found in Authorities Bundle, I think it's tab 2. Page 105. And goes to paragraph 190. Is it paragraph 190? Forgive me, it's not. It's page 190.
Could you give me paragraph number? Because I've got it.
Forgive me, let me just have a look.
It'll be 220 or 221 or 219.
Page 182. Oh yes, it is 190. Forgive me. It is 190.
Either paragraphs 219
or 219.
In fact, can we look at paragraph 190 before I go to my latest paragraph? 190. there the court, or rather the majority said, whether an event which is one of very many that combine to cause loss should be regarded as a cause of the loss is not a question to which any general answer can be given. It must always depend on the context in which the question is asked. When the context is a claim under an insurance policy, judgments of fault or responsibility are not relevant. All that matters is what risks the insurers have agreed to cover. We've already indicated that this is a question of contractual interpretation, which must accordingly be answered by identifying objectively the intended effect of the policy as applied to the relevant factual situation. And that is a reflection of what was said at paragraph 162 at page 173 of the bundle. Where it is explained at the foot of the page, about 7 lines from the foot, although the question whether loss has been caused by an insured peril is a question of interpretation of the policy, it is not, unlike the questions of interpretation of the disease, hybrid and prevention of access clauses considered above, a question which depends to any great extent on matters of linguistic meaning and how the words used would be understood by an ordinary member of the public. What is at issue is the legal effect of the insurance contract as applied to a particular factual situation. And then in the succeeding paragraphs, the judgment goes on to deal with the meaning of proximate cause and concurrent cause. But at the end of the day, whilst it is not the same test, it's not the same exercise of construction that one necessarily applies, say, to words, it is nevertheless a matter of interpreting what objectively is the intention of the parties, is the meaning of the causation requirements of the clause or the cover in question. So the judge should have resisted the temptation to treat the FCA case as supplying the default answer to this case. So what really you should be doing is the exercise upon which I've engaged you, and then to look at the FCA case to see whether it confirms or doesn't confirm your views and why, and whether it's distinguishable, etc. Don't start with the FCA case. And it's not only the wordings in FCA that were different. The arguments in FCA were also necessarily different. And if you could turn, for example, to paragraph 50 in the FCA case at page 148, you'll see a typical radius clause there in RSA 3, Royal Sun Alliance 3. And if you look at the paragraph, you will see that that indemnifies, in respect of interruption or interference with the business, following any occurrence of a notifiable disease at the premises, or attributable food or drink supplied from the premises, or the discovery of an organism, etc. And then 3, the occurrence of a notifiable disease within a radius of 25 miles of the premises. So you've got, firstly, notifiable disease at the premises, but it's little 3 which was relevant to the court's determination, an occurrence of a notifiable disease within a radius of 25 miles of the premises. You turn to paragraph 54, you'll see the competing arguments. There are 2 main issues about how the disease clause in RSA 3 should be interpreted. The first is what is meant by the words in A3 of the insuring clause, any occurrence of a notifiable disease within a radius of 25 miles of the premises. What is the scope of the peril insured against by this provision? RSA contends that the clause only covers the business interruption consequences of any cases of a notifiable disease which occur within a radius of 25 miles of the premises insured under the policy. Any cases outside that area do not form part of the insured peril. The FCA's position, on the other hand, is that clauses should be read as covering the business interruption consequences of notifiable disease wherever the disease occurs, provided it occurs, meaning that there is at least one case of illness caused by the disease within the 25-mile radius. That's the first issue, which was decided in favour of insurers and against the FCA. The dissenting judges, Lords Briggs and Hodge, thought that the contract meant, as the divisional court had said, but they were in the dissent. The second issue, which has to be approached in the light of the answer given to the first, is what causal link between the insured peril and the interruption to the business is required in order to entitle the policyholder to be indemnified under the clause.
You say they were only addressing that question to A3 when they talked about the insured peril, even though they had specifically italicised as one of the key passages at paragraph 50, A1.
Correct. And if you want me to read out in extenso what they were addressing, that's all they addressed. Say for one, with one qualification to which I might as well come to it now. The only time that they address those italicised words is at paragraph 71. Once it is recognized, that's page 153. Once it is recognised that the words occurrence of a notifiable disease refer to an occurrence of illness sustained by a particular person at a particular time and place, it's apparent that the argument that the disease clause in RSA 3 applies to cases of illness resulting from COVID-19 that occur more than 25 miles away from the premises should be rejected. As a matter of plain language, the clause covers only cases of illness resulting from COVID-19 that occur within the 25-mile radius specified in the clause. That is consistent with the other sub-clauses of the extension. In each case, they cover events or the discovery of events that occur at the premises. That is to say, at a particular time and place. They include in A1, this is the passage, my lord, any occurrence of a notifiable disease as defined below at the premises. The FCA has not sought to suggest that this sub-clause provides cover for all the business interruption consequences of a notifiable disease wherever in the country or the world it occurs, provided that, and from the time when, there is at least one case of the disease at the premises. The language of the policy is not reasonably capable of bearing that meaning. By the same token, and for similar reasons, the interpretation which the FCA has sought to place on sub-clause A3 is not, in our view, a tenable reading of the policy wording. And then, if you go, my lords, my lady, to what the FCA actually said, which is worth having a look at. If you go to supplementary bundle, to divider 27, you will see at page 121, this is the written case of one of the insurer appellants. And if you go to page 122, paragraph 42, the fallacy of the court's approach can also be tested by reference to separate cover for the business interruption consequences of notifiable disease at the premises. The logic of the court's reasoning is that once the proviso of notifiable disease at the premises is met by proof, even years later, of a single undiagnosed case of COVID at the insured premises, the insured would recover for all loss caused by the national COVID-19 epidemic and even possibly the global pandemic. This would clearly be contrary to the parties' intentions in agreeing narrow cover for the business interruption consequences caused by notifiable disease at the insured, as defined at the insured premises. Now, in fact, the FCA did not dispute that.
Is this submission dealing with the what is the scope of the peril?
Correct.
Rather than the causation.
You're absolutely right, my lord, but it is still relevant if I might respect.
No, carry on.
But your lordship's entirely right. Your lordship's entirely right. If you go to the FCA's response in the next divider, SB 28, and you go to page 124, the FCA said this at paragraph 194. Clauses the nature of the cover provided by these at the premises is different, because the contemplated interruption and authority action caused by a disease occurring at the premises will be different to interruption and authority action caused by a disease occurring away from the premises. In the former case, the premises is likely the source of the disease, as is explicitly required in relation to a food or drink part of such clauses, and the risk is that it continues to produce that disease or illness, as in the case of Legionnaire's disease or food poisoning, and or that the disease may get out of the premises and in so doing spread to others. The clause envisages measures directed specifically at the premises to stop that repetition or spread, measures that would not be taken on a national or wide area basis. The fortuity is therefore, as a matter of construction, contemplating and limited to the at the premises aspect of any disease, not a wider outbreak. The radius clause is different. It recognises instead that the insured could get caught up in measures which are not directed at or specific to the policyholder at all, but which are taken to suppress an outbreak of a notifiable disease that is present anywhere within that radius, including for public health reasons. The reason the business is interrupted is usually where any case within 25 miles triggers the clause, not because of a concern that the premises is a source of infection, nor that the fabric of the premises may itself become infected. The primary reasons are more likely that the disease may be spread by people being in close proximity to each other, which the authority aims to prevent, as a result of travelling to or from or visiting or working at business premises, either generally or within the categories into which the insured's business falls, and or that an outbreak will suppress the insured's own trade, such as by reduced footfall. In those circumstances, within a radius of 25 miles of the premises is adjectival, and the intention is to cover outbreaks inside and outside the radius, whereas at the premises limits the fortuity, requiring a link between the occurrence at the premises and the interruption. Well, Mr. Edelman's submissions there did not have to be dealt with by the Supreme Court precisely, although they did deal with that point in their determination on construction. But those submissions could as well be my submissions today on the meaning and scope of at the premises cover, but it's very important to note that you do not in any way separate your determination of the causal requirements of the cover from the meaning of the cover that is provided. In other words, the meaning of the cover and the causal requirements are all part of one interpretative process. You don't compartmentalise them. You ascertain the causal requirements by reference to the meaning of the cover that is or is intended to be provided. Now, the point that we make, of course, is not the submissions that I've just taken to you as some sort of authority. They were merely arguments that were advanced. The Supreme Court didn't need to make a decision in relation to the causal elements, but they're relevant in two ways. First, they reinforce the point that the Supreme Court, when dealing with causation, was not concerned with at premises clauses. One should hesitate to read across the logic of its decision and treat it as being indicative of the correct construction of at premises clauses, because neither side before the Supreme Court was suggesting that at premises clauses would respond in the manner that the judge in this case has held that they do. And secondly, the submissions articulated a perfectly commercially sensible distinction, which we endorse, between radius cover and at premises cover, which would justify and explain the presumed intentions of the parties to an at premises clause being different from those of the parties to a rages clause. The causal requirements are different. And as I've indicated, if you remember Lord Mance in China Taiping, he identified why it was that the meaning of clauses with limitations may be that the clauses are given a perfectly good meaning, and indeed the right meaning, even though parties can contemplate that events may occur which mean that the business interruption losses and the events which have given rise to the business interruption losses are simply not covered. As he identified in that case, it's the same commercial distinction between the risk of localized interventions and nationwide interventions, just as he recognized in relation to the competent local authority discussion. So going back, we go back to FCA, if we may, and it's important that you look at paragraph 57. Because paragraph 57 is looking at a rageous clause and the factual context of a rageous clause. And this is the same factual context in which the Supreme Court later in its judgments determined the causation requirements of a rageous clause. So this applies as much to construction as it does to causation. As much to scope as it does to causation, which are both issues of construction. Now, if you could read paragraph 57 to yourselves, my lords, my lady, I will then, as it were, address it. I suspect this is a Lord Legate exercise, in which case you have to read it quite carefully. It's in the context of this paragraph that I will turn in a minute to paragraph 194, which is probably the most important paragraph in the Supreme Court's judgments concerned with causation.
Are you saying that there are any aspects that are there identified that don't apply to at the premises clauses?
Yes, we do. We have no problem with the paragraph as a whole, but in two material respects, we say that it's not apposite to our ATP clause, yes. Sentence 4, an outbreak of such a disease could potentially affect a wide area and cause interruption to businesses over a wide area, a risk clearly contemplated by the policy, which recognises that the occurrence of a notifiable disease up to 25 miles away might lead to interruption of business at the insured premises. Now, I could transpose that in the following words. An outbreak of such a disease could potentially affect a wide area and cause interruption to businesses over a wide area, but that's not a risk clearly or at all contemplated by the policy, which only recognises that the occurrence of a notifiable disease at the premises might lead to interruption of business at the insured premises. That's the first thing.
So you say the parties would contemplate that possibility, but the policy doesn't.
Exactly.
Is that the distinction?
Exactly so. Yes, exactly so. What matters, if you want to copy down my notes, is what your lordship has just said, is not that the risk was being contemplated by the parties in the sense that they could have foreseen it as a possibility, but that it was clearly contemplated by the policy, and specifically a radius clause. That is precisely the point. The closure of premises under such a clause is because of what is happening outside, external to the premises, where the business interruption occurs and the loss is suffered. Because of a case of disease that is external to the premises and external to the insured's business at the premises. How can that be? How can such a case cause business interruption at the premises? How can it ever result in the closure of the premises? But as the Supreme Court here makes clear, and later, it is because a radius clause involving disease within the radius that causes interruption to the business some distance away intrinsically involves, one, the existence of a widespread disease, and two, a widespread authority response to that widespread disease. It is the intention of the radius clause that the occurrence of that external peril should qualify as a proximate cause within the meaning of the clause. The risk of business interruption by virtue of authority intervention over a wide area was indeed intrinsic to the very nature of the insured radial peril. That is very much not a risk that is intrinsic to, let alone clearly contemplated by our clause, which only and exclusively contemplates and recognises that the occurrence of a notifiable disease, food and drink poisoning, etc., at the insured premises might lead to the closure of those premises or a part thereof. That is a targeted risk, and the policies recognition of it are very significant. The disease risk insured in our extension is internal to the insured's premises and internal to the insured's business, where the business interruption loss is suffered. Unlike a radius peril, which is external, it is intrinsic to the nature of an at the premises peril that the closure of the premises is because of that which is happening at the premises.
And that doesn't depend on the size of the premises. It may be that a radius clause within 1 mile of one premises would be a smaller area than just the premises of a much larger concern.
Again, we're back to radius. And if you had a...
It's the radius element. I understand why you take the 25-mile example.
Yeah.
But you're saying that radius clauses all mean that widespread area response is intrinsic.
Yes.
Because
Yes.
of the size of the area.
Yes,
Essentially.
that's right.
But if the size of the area can be just as large for an at the premises,
Oh, a
policy,
fortiori
then-
for my case. If indeed, let's say the premises are at 1 square mile, I mean, let's just assume that for present purposes,
yes,
then you're much more likely to have a response by the authorities to what is happening in those premises, specifically in relation to those premises. And therefore, that, if anything, that reinforces my argument. So if you say, oh, well, business interruption at Glastonbury as a result of disease at the festival, well, that's not a good example. But if you were to say, I'm insuring the Glastonbury Festival premises, in other words, everywhere, against disease at the premises and business interruption as a result of disease at the premises, then, of course, you're going to say, it's those horrible, dirty people at Glastonbury with all their diseases which have attracted the government or the local authority to close down Glastonbury and send everybody home, including Madonna. So a fortiori in my case. So it's very important that you recognise in our submission that the express contemplation of the policy, forget about the parties, but of the words of the policy, which is the record of the parties' bargain, is that of a response involving the closure of a business premises due to an occurrence or outbreak at those premises, that's to say, as a result of disease being at those premises, in as it were, in contradistinction, not as opposed to, but in contradistinction to anywhere else. And in further answer to my Lord, Lord Justice Popplewell, we're not saying, by any means, that it's just the geographical size of the premises that matters, quite the contrary. It's disease which is external to the premises that has spread to the community, thus meaning that the premises are closed.
That's to assume that the disease hasn't spread to the premises as well.
It may be that you have the disease at the premises as well, but if you're going to have coverage under this clause, you will have coverage because the premises are closed because of the disease at the premises as well. But there's the connection between the premises and the closure order. Now, there is actually in our policy, I should take you to it, a clause that does recognise the risk of disease, including a notifiable disease, far away from the insured premises, nevertheless having a business interruption impact on the premises. There is such a clause. And that is the denial of access non-damage extension clause, which is in the policy at CB2, divider 32 at page 554. So it's not as if the parties to this policy have not recognised in the wording of this policy something very much like a wide-ranging disease involving wide-ranging response. If you could go, my lady, my lords, to page 554, this is in the same document as our infectious disease extension, but at 554, there is what it describes an NDDA clause, a denial of access non-damage or a non-damage denial of access extension. It's the latter which attracts the NDDA acronym. This clause applies to the business interruption insurance section of this policy. Cover 10. Any other accident, your lordship and my lady will remember that that's any other accident in cover 10, is extended to cover interruption of or interference with the policyholder's business in consequence of access to the premises being hindered or prevented as a result of the actions or advice of a government or local authority due to an emergency arising which is likely to endanger life or property at or in the immediate vicinity of the premises, provided that there shall be no liability under this extension for, and there are various exclusions, one of which is for any consequence of labour disputes, infectious or contagious diseases, drought. Now, we're not saying that somehow or other this clause and the disease extension clause are mutually exclusive. If you don't find cover under this clause, we accept that you might find cover under the infectious diseases extension if it exists. But what this clause demonstrates quite clearly is that the parties were fully alive to the risk of infectious or contagious diseases being in the vicinity, in the area, or, if one wants to put it another way, infectious or contagious diseases being everywhere, but likely to endanger life or property at or in the immediate vicinity of the premises. and they quite clearly contemplated access to the premises being hindered or prevented as a result, includes closure, as a result of the actions or advice of a government or local authority. Now, there's been a debate in some of the cases about whether the emergency has to be in the immediate vicinity of the premises, or whether the emergency can be outside the immediate vicinity but cause a hazard or cause danger to life or property in or at the immediate vicinity of the premises. There's been some discussion about that, which I don't need to take you to. The importance of this clause, my lords, is that the parties did contemplate this, but that clause makes it clear that such a disease, in other words, wide-ranging disease attracting wide-ranging reaction, and its consequences are not covered under that clause. But it is in telling and important that whilst the parties clearly recognised wide-ranging disease attracting wide-ranging authority action, what they provided, what the insurers provided, and what the insured agreed to accept was cover with a limitation referable to disease at the premises. There is not, in our case, as there was in FCA, the contemplation and recognition by the policy of a widespread response by the authorities to a widespread disease being a covered risk. Now, coming back to FCA in paragraph 57, that authorities bundle tab 2, page 150, my Lord Justice Popplewell asked me whether I agreed or I had any problems with 57, and I identified one thing. And in relation to the fifth sentence, which begins, the parties must also have contemplated that the authorities would be likely to take action in response to an outbreak of a notifiable disease as a whole and not to particular parts of an outbreak. We don't, in fact, agree that that necessarily follows. It all depends, of course, on what the outbreak looks like and the timing of the response and all the circumstances. Insofar as this sentence is directed, as possibly it is, to a situation where the disease in question has already spread far and wide, we accept that it would be irrelevant to any action taken by the authorities, whether the cases of such a disease happen to have fallen within an insurance agreed line of 25 miles away from the insured premises. That we accept, because a radius clause, whether it's 1 mile or 25 miles, is an arbitrarily determined radius in a private contract between insured and insurer, in which, of course, the local authority or the central government would have absolutely no interest. It is, as I've indicated, something which is described by the SCA, by the Supreme Court as a hard-edged rule, and for your reference, that's paragraph 205. Now, by contrast, taking sentence 5, in the context of our clause, it would and could well be relevant to any action taken by the authorities that cases have occurred at the specific insured premises. It is entirely intelligible that premises would be closed by reason of disease being present there. This is something which obviously can and does occur, even in the context of diseases that can spread or have spread far and wide. And it is exactly as I've indicated what happened in Hong Kong, and later in July 2020, you've seen Mr. Hancock and Mr. Johnson. The background, therefore, in paragraph 57 is broadly accurate so far as it goes. We accept that. But the important thing is that it does not read across to tell you what is being contemplated by the relevantly different wording of an ATP clause.
The last sentence would be a fortiori, wouldn't it, in relation to an ATP? And it would read, the parties must also have contemplated that the authorities would be likely to take action in response to an outbreak of a notifiable disease as a whole, and not to particular parts of an outbreak, and that it would be irrelevant to any action taken, whether the case fell at the premises or outside the premises. When that would be obviously equally true. I understand your point that we're not concerned with what the parties contemplated as the response, but whether the policy contemplated that there would be cover for such response. But the 25 miles isn't determinative of the last sentiment in relation to what parties would have contemplated as the response.
Well, I actually think that the last sentence is running seamlessly from the anterior sentence. In other words, in the anterior sentence, what you see the Supreme Court saying is a disease could potentially affect a wide area and cause interruption, a risk clearly contemplated by the policy,
yes,
which recognises the occurrence of a notifiable disease that might lead to the parties must also have contemplated that the authorities would be likely to take action in response to an outbreak of a notifiable disease as a whole, and not to particular parts. Well, that is, as it were, a fortiori in case of a radius, because it would be irrelevant whether it fell inside or outside the line of 25 miles away. So the context in which that last sentence is talking about is you've got a radius of 25 miles, you've got a widespread disease, you've got a government authority action which affects the premises, so it's going to be a wide-ranging response, and it's going to be taken in response to the disease as a whole, and it doesn't matter whether it's a response to those within the radius or those outside the radius or to both. That's completely different from an at the premises clause, when you're talking about, well, if you're saying that the parties must also have contemplated rather than the policy must, I'm so sorry, that's my fault, then our case is a fortiori. The parties must have contemplated that, and indeed, in a sense, forgetting about the precise radius, they did contemplate that in the NDDA clause. And then what you find is that the premises clause does not have anything.
Yes, well, that's the point I'm putting to you.
I'm so sorry.
The last sentence, I don't think, involves any distinction between a radius case and our case. It's simply what the parties contemplate.
Exactly.
And if they contemplated being outside the geographical area for a 25-mile radius case, then a fortiori they'll contemplate it for a smaller area.
Possibly, yes. I mean, the possibility is always there. Of course it is.
As I say, that doesn't cut across your point that it's a matter of what the policy contemplates rather than what the party.
I'm so sorry. That was me being rather trigger happy.
That was the only point I was making. I'm not sure that the last sentence itself is a point of distinction.
No, but I think actually what you've just done is to have stirred me into looking at paragraph 194. And perhaps one looks at 192, page 182, the foot of that. Three lines from the foot in particular, it is necessary to ask, would the causal requirements imposed by the word following be satisfied by showing that, my lord, well, by showing that one or more cases within the next 5 years of national restriction of interruption was the basis of those concurrent cause, all cases will be of approximately equal weight. That's the FCA provisional court alternative conclusion. Or a weighing test. The weighing test is a test where the cases within the radius are weighed against the cases outside the radius. It is determined whether or not weight or not, and that determines the causal connection. That determines the causal, whether the causal test is satisfied. Then the majority go on. In deciding between these competing interpretations, we consider the matters of background knowledge to which the court below attached weight, and I've taken you to, in interpreting the policy wordings are important. The parties to the insurance contracts may be presumed to have known that some infectious diseases, including potentially a new disease like SARS, can spread rapidly, widely, and unpredictably. Tick. It is obvious that an outbreak of an infectious disease may not be confined to a specific locality or to a circular area delineated by a radius of 25 miles around the policyholder's premises. However, no reasonable person would suppose that if, and could you please put a nice red circle if you're using a red pen, if an outbreak of an infectious disease occurred, which included cases within such a radius, and, could you put a little circle round and, was sufficiently serious to interrupt the policyholder's business, all the cases of disease would necessarily occur within the radius. It is highly likely that such an outbreak would comprise cases both inside and outside the radius, and that measures taken by a public authority which affected the business would be taken in response to the outbreak as a whole, and not just to those cases of disease which happen to fall within the circumference of the circle described by the radius provision.
And you say that applies mutatis mutandis to cases of disease which happen to fall within the premises?
I say exactly the contrary.
If you, in that sentence, you substituted a radius for the premises, but forget the infelicities in grammar, but so if it read,
oh, I see.
If an outbreak of an infectious disease occurred which included cases within the premises and was sufficiently serious to interrupt the policyholder's business, all the cases of disease would necessarily occur within the premises.
No, I don't accept that. I don't think necessarily all the cases would.
Forgive me. You say that wouldn't be expressing the same sentiment because of the reference to sufficiently serious to interrupt the policyholder's business.
Correct. Correct. That's absolutely right. In fact, all the parties would contemplate that if there was an outbreak or infectious disease at the premises, and that was sufficiently serious to interrupt the policyholder's business in the premises, then necessarily the cases at the premises will be the reason why the business has been interrupted. Now, it is not highly likely, it might be, but it's not highly likely that such an outbreak would comprise cases both inside and outside the premises. Depends on the facts.
Well, it is in the case of the kind of infectious diseases that are here being considered.
Yes, but it depends on the facts. I mean, you may actually get the disease before it spreads, but it is entirely possible that it will, and that measures taken by a public authority which effectively is taken in response to the outbreak as a whole, and not just to those cases which happen to be within the premises. But what you're reading into there, you're doing almost the same as Mr. Justice Jacobs, which is almost saying, well, how can we fit our case into what the FCA the Supreme Court is saying? You've got to start really from the base position, which is that it was a radius clause. They're not considering at the premises. They're not thinking, what would Lord Legate say to himself if I have to decide what the ATP clause means? They're not saying what I'm saying in relation to a radius clause somehow can be translated or transposed into an ATP clause. That's not how people think. That's not how Lord Legate, dare I say it, thinks, or Lord Hamlin. They're just focusing on what they've got, which is a radius clause, and they're accepting it is highly likely that such an outbreak, well, what is such an outbreak? If I might be so bold as to inquire. Such an outbreak is that in the preceding sentence. It is an outbreak of infectious disease which included cases within the radius and was sufficiently serious to interrupt the policyholder's business. That's what they're talking about. So the idea that you can just shove in at the premises, hey presto, there's an answer, is just wrong. It's highly likely that such an outbreak would comprise cases both inside and outside the radius. Well, that outbreak is one which includes cases within a radius of 25 miles, and two, was sufficiently serious to interrupt the policyholder's business 25 miles away. And it is that outbreak which the cases of disease would not necessarily occur within the radius, of course not. It is highly likely that such an outbreak would contain cases both inside and outside the radius. If you've got a case 24 miles away, which is going to be so serious as to cause your premises to be closed down, then that is going to be a serious outbreak, and it's highly unlikely that the disease, let's call it COVID-19, is going to get to the 25-mile mark and say, oops, we've got to stop here. That the virus is going, well, it's not COVID-19, it's the virus, SARS-CoV-2. All the viruses are going to go to the 25-mile mark and say, whoops, oh, we can't get through, we better go to turn back. In other words, if you've got SARS-CoV-2 25 miles away, it's not going to be confined to 25 miles away. The radius of 25 miles is a privately constructed, contrived, hard-edge rule, as the court says later, which is private and arbitrarily decided as between insured and insurer. And neither the government, nor dare I say it, a virus, is going to pay much attention to it.
But the same is true of a single case at a nightclub, isn't it?
A single case at a nightclub?
Yeah.
Yes.
Well, a single case at a nightclub is, will, according to, an at the premises clause contemplates a single case at a nightclub, causing that nightclub to be closed down. It doesn't contemplate a wide-ranging government response as an intrinsic quality of the clause itself.
Why not? If a policy can respond to known unknowns, and this may be where that you're drawing the line, but if a policy can respond to known unknowns, whether we go back to our rats example or we have COVID as an example, whatever, then the contemplation of the parties as to what the public response will be to a known unknown doesn't posit knowledge of something at those particular premises. It is contemplation of a widespread public response on a more general basis.
Yes, but I'm afraid you're...
I may only be restating the argument as opposed to...
Well...
my way towards. Is it really your case that at the premises policy can never respond to a known unknown response by,
No, it's not my
by
case.
authorities?
No, it's not my case. No, I made that clear before Mr. Justice Jacobs. But dare I say it, you're conflating parties' contemplation with policy's contemplation. In looking at the policy contemplates, all the policy is contemplating is a case of disease at the premises,
Yes.
resulting in the premises being closed.
Well, unknown. A case of disease at the premises, possibly undiagnosed and asymptomatic,
Well,
and the premises being closed as a result of it being,
at
as
the premises.
described here, a highly contagious disease, which covers the area in which the authorities are taking into account known unknowns as well as known cases.
No, the premises being closed because of the case of the because of the case.
That's what I'm struggling with.
Well,
Mr.
I
Keeley.
understand that's your
Well, no,
position
no.
as what it means, but
I'm struggling to understand how your analysis of the causal link, which requires that the order of the authority which closes the premises is in response to a belief or reasonable belief that there is a case on the premises of whatever it may be, or a rat, could ever apply to a known unknown.
Oh, no. Well, let me explain to you. Let us just say that a local authority says there are rats in this street, and we think that those rats will have entered every single restaurant. It's not a risk of rats going in, it's the fact that rats have gone in. We don't know, because we haven't seen the rat in question. We don't have a photograph of it. But we can tell whether, as a matter of common sense, that rats will be in these restaurants, which is why they have to be closed. Not because of the risk of rats going to the restaurants in the future, not because there's a national rat pandemic. They are being closed because those restaurants are infected by rats.
They're being closed because there's a reasonable belief that those restaurants are being infected by rats.
That is sufficient to trigger the causal connection.
But if conversely, what the council is saying is we've no idea whether they're there, but there's a real risk, that's not sufficient.
Good enough.
No, that's not sufficient. I mean, a real risk is actually, well, we all can sort of try and work out what a real risk is as opposed to an unrealistic risk or an unreal risk. But yes.
But in the real world in which one's contemplating an authority, whether it's local governmental authority response to these kinds of insured perils, whether they be rats or whether they be highly infectious, fast-spreading diseases, is it realistic? A distinction as contemplated by the parties at the time the policy is entered into between a council who says on the one hand, I've no idea whether there are rats there at the moment, but there's a real risk and we need to shut it down before they scootle along and get in, and one that says, well, we think we've probably got as far as number 52, therefore everybody up to 52 is covered, but number 54, kebab shop, not covered.
Are there many kebab shops in Upper Street? Well, maybe they're all kebab shops.
I'm afraid even in gentrified Upper Street there are plenty of kebab shops, but that
Right.
doesn't really, that's not going to determine the outcome of the case.
I don't know. I think it might.
But you see the point. And
No.
one's looking at what we're going back to. What would the reasonable SME policyholder have thought
Well,
was covered or not? To draw a distinction between a wide area or even narrow area, but area response by an authority, based on the one hand on more than 50% belief, and on the other less than 50% real risk.
I
might
think
strike the SME policyholder as surprising.
Well, what wouldn't cause him any surprise is if he were told, you are covered if your premises are closed because of rats on your premises. And then it's a question of identifying whether your premises have been closed because of rats on your premises. If your premises are closed because of some blanket decision that all premises should be closed, whether or not they actually have rats, then you're not being closed because of rats on your premises. Dare I say it, a normal person would look at this and say, well, I don't know what the facts will be, because the facts will be what the facts are. But when the facts arise, I will have to ask myself whether the relevant causal requirement has been satisfied. He won't put it quite those terms, but what he or she will say is, have I been closed down because of COVID, because of rats on my premises, as opposed to rats which could be anywhere else.
Well,
And
I would have thought if the blanket order says we're closing all of these premises because we think there are probably rats there, and it turns out there are rats in your premises, then you would be covered, and the policyholder would think you would.
But that's fine. That's fine, my lady. If that's what the authorities, and that's what you would expect the authorities in normal circumstances, this isn't, by the way, a paradigm case. This is just normal common sense. if authorities are going to close down a premises because of rats, it will be normally because, forgive me, it'll be normally because of rats being there or rats likely to be there.
Well,
But-
can I just,
Sorry.
certainly if one's talking about diseases of the kind we're talking about, the kind of public response that must have been contemplated would include a prophylactic one,
Yes.
i.e. one which didn't take account of what was there at the time, but was in order to prevent occurrence at the premises. But you say no cover for prophylactic.
cover.
No cover for prophylactic measures.
Absolutely not. And we use, I think, the word prophylactic in our skeleton, I suspect. Do we? Probably.
That doesn't
yes.
matter. We all know what
Mr. Howie
we all know
knows.
what we're talking about.
Yes.
But
Absolutely there wouldn't be
if
cover.
with these kinds of diseases that are covered, prophylactic measures are very much the kind of measures which can be expected.
Yes.
It would be surprising if the policy doesn't respond to prophylactic measures, wouldn't it?
Not at all. It doesn't say the risk of disease at my premises. It says an occurrence of disease at my premises.
Yes.
And the idea that
So
an
we cover
occurrence...
for prophylactic measures if it turned out that the prophylactic measures didn't work and there were in fact rats on the premises.
Well, I'm sorry, but no. What you're doing is contemplating possibilities. And we know that in our case, the government responded to information about all cases everywhere. It wasn't relevant to them in the slightest whether a case was at a particular place or not. That's the first thing. The government didn't respond in the case of the centre to the centre having disease or the centre having rats. The centre was closed irrespective of anything that was occurring at the centre. There is no evidence, and there could be no evidence, that the government closed down the centre because of any disease at the centre. That's the first thing. Secondly, let's just assume that there was no disease at the centre, and what the government did was to impose its lockdown in order to, as it did do, as it expressly did, which was to contain the spread of the disease. Now, if you asked, you say an SME, if you asked, this may be more than an SME, but it doesn't really matter. If you asked the parties to the contract, is that good enough? And the answer came, well, what the contract provides is that there should be an outbreak or an occurrence of disease at the premises, which results in the closure. I think, I would hope to say, that most ordinary, reasonable people would say, well, if all you're taking is a prophylactic step to prevent disease from getting there, then the requirements of the cover are not satisfied. And in fact, probably you don't even get to causation because the scope of the cover doesn't extend that far, because there's no occurrence of disease which has caused the premises to close. Because if it's prophylactic, then you're trying to stop the spread rather than because there's an occurrence.
No, but it may in fact be there, but
Look, we can go round and round in this, and that's not me being, as it were, frustrated, but, and probably is you being frustrated, and I'm probably frustrating you. But the fact is that if you go back in time, if you actually look at this contract by reference to what the parties would have thought when they entered into it, with the contemplation that there could be a pandemic, because that is within the reasonable contemplation of the parties, there can be notifiable diseases which spread rapidly and attract widespread governmental response. So that's the state of mind of the parties. And they then look at this clause, which talks about an outbreak at the premises, an occurrence at the premises, causing the local government or the central government to close the premises. Dare I say it, a normal person will say that there is a direct causal link between that which occurred at the premises and the need or the demand that the premises close. Not anything prophylactic, not anything about, oh, well, there's disease everywhere, whatever that means. I mean, disease everywhere is simply just a throwaway line in a sense. There's disease everywhere, but there's disease nowhere. You can say there's disease everywhere, but there's not necessarily disease in this court. There's not necessarily disease at the centre. There's not necessarily disease anywhere particular.
Right, well, we won't go round and round anymore, at least for the time being. We'll let everybody go off to the kebab shop and 2:05.